Okay, now, ladies and gentlemen, we are deeply honored to welcome the Coordinating Minister for Law, Human Rights, Immigration, and Correction Institution to deliver the opening speech, Professor Dr. Yusril Ihza Mahendra, SHMSC. The stage is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. Assalatu wassalamu ala Rasulillah wa ala alihi wa sahbihi ajma'in amma ba'd. Honorable Rector of Andalas University, Honorable Dean of Faculty of Law, Andalas University, Honorable Dean, Melbourne Law School, distinguished speakers, distinguished provincial governments of West Sumatra, distinguished participants, ladies and gentlemen. Allow me to express my sincere gratitude for the honors of speaking before this distinguished audience of the legal scholars and practitioners. I highly appreciate the themes of the year's conference, Legal Reform, Inequality, Equitable Law Enforcement in Indonesia, as pursuit of legal reform and uphold social justice, and indeed our shared responsibility. As an introduction, allow me to recall the words of the late Professor Mushtaq Maja, who once said that law is a means to maintain order and justice within society. This statement reminds us that the function of law was always oriented toward serving the people and ensuring justice, not merely the rigid rules. When we speak of legal reform, our imagination often drifts toward parliamentary buildings and legislative stacks. However, law is like an ecosystem. It not only grow from the state, but also live from judicial decisions, the customs of business actors and the legal professionals, the thoughts of the scholars, and the practices deeply rooted within a society. Law can emerge from various sources. It is not static, rather, it is the result of the dynamic interactions among different actors within a society. In legal scholarships, we often encounter the expression that law not solely states law, that is, law made by the state stroke legislations. Law can also originate from judiciary, judge-made law, where judge stroke their decisions create precedents, formulate ratio decidendi that guide future legislation and often upon the new norms. As I mentioned in my public lecture in Surabaya last October, law is not only the state's law produced by the state, but also the judgment law, the lawyer's law, the professor's law, and the people's law. All of these codes of law, including social traditions, interact to form our legal system. Therefore, the government's task is not choose one source of law of another, but rather to harmonize them, all so that our national law will live, breathe, and stand for justice. Furthermore, there is what we call lawyer's law, law that develops the practice of lawyers and legal professionals, shaped by personal customs, contract, corporate governance code, and compliance guideline. Also often referred to as a soft law, it is the regulatory power is tangible, as it's been the practice the parties involved in face regulatory gaps. There is also professor's law, which emerged from the ideas of the scholars at the university, legal doctrines, academic teachings that later influenced the legal practice and judicial decisions. In many instances, academic doctrines serve as the authoritative references for interpreting norms. And finally, no less important, there is people's law, customary law, religious law, that grows organically from the customs, tradition, religious teachings, and unwritten social norm at communities, yet exerts the strong influence. People's law may take the form of customary practices or community-based dispute resolution mechanisms. In many legal systems, such living law is recognized as long as it does not contradict national law or human rights principles. By understanding the various sources and creatures of law as described above, we can also anticipate where the legal reform originates. Legal reform might arise from the state initiative or, for instance, through legislative reform designed to address contemporary challenges. The state undertakes reform as a response to shifting public policy needs when the digital economy demands personal data protection, when the climate crisis confronts new governance of natural resources, or when demographic change and urbanization alter patterns of the legal dispute. However, reform may also emerge from the judiciary when judges reinterpret existing laws in a new ways, creating reform for judicial decisions, much like the Constitutional Court and the Supreme Court have done in many countries. These institutions often act as the locomotive for the reforms through their progressive interpretation of the Constitution. In addition, reforms may come from society itself, such as stroke social movement. Consider how Indonesia's anti-corruption movement led to the establishment of the Corruption Eradication Commission and the enactment of various new legislation, or how the human rights movement encouraged the ratification of numerous international conventions. Lawyers and legal practitioners also frequently play a vital role as catalysts of the change the drafting initiative for contracts models for engaging advocacy drives policy transformations. Many landmark judicial decisions were inspired by the creativity and boldness of the legal argument presented by the lawyers, which is turned prompted progressive judicial breakthroughs. Legal reform may also emerge from academic doctrines. Theoretical ideas expressed through expert opinion in court, academic papers, or scholarly views presented in parliamentary hearings often serve as a key inspiration for the legal reform. If we observe developments across various countries, it becomes evident that legal reforms doesn't always originate from the legislative reform initiated by the government or parliamentarian or the politician, but come from the public, come from the people, come from the academic in various universities. Ladies and gentlemen, let us take a historical perspective. Our legal system is a result of the long accumulation of influence by various sources of law. Even before the arrival of the Dutch, the people of the archipelago already pressed the adat or the customary law and the Islamic legal traditions that were deeply embedded by their daily life. The Dutch colonial era introduced the Roman Dutch legal system, such as the burgerlijk wetboek or civil court, the criminal court, and the court of criminal procedures, which was initially applied only to the Europeans, but later extended more broadly. During the Japanese occupation, the legal structure shifted toward the militaristic systems. After the proclamation of independence in 1945, Indonesia inherited numerous colonial regulations, yet we sought to establish a new legal foundation based on Pancasila, the state philosophy, in the Constitution of 1945. The Pancasila doctrine, conceived by Supomo and his colleague, calls for the legal system rooted in the strengthened adat law and the Islamic tradition and the nation's cultural values. Therefore, Even though the new order regime attempted to unify the law, other law continued to be recognized as the soul of the Indonesian law. The era The reform era used the renewed spirit of transformation of Constitutional Amendment of 1999 to 2002, in which I had honor to participate. The enactment of the human right law and continuous effort for strengthen the judiciary and enhance public protection. From this long historical journey, we can observe that Indonesian law is inherently pluralistic, integrating Western's nation of the rule of law, social cultural conception of justice, and the moral foundation of the religion. Legal reform might originate from diverse sources, driven by a wide range of actors. Indonesia possesses unique characters that make the process of the legal reform fascinating and challenging. We live in a crossroad, the three powerful legal traditions, Western law, which introduced codification and modern institutions, Islamic law, which governs matters of personal status and has rapidly expanded in the field of Sharia economic and other customary law, which reflects the sense of justice within the local communities. The constitutional duty of the government is not choose one of sources, one part of the legal reform of another, but to orchestrate all the legal systems to recognize the living law without undermining the equality, to develop Sharia-based system within a framework of the professional governance, and to ensure that codified law remains relevant in response to the changing world. From my personal experience, I have been privileged to gain extensive insight into legal reform. As Minister of Law and Legislation, and later as the Minister of Justice and Human Rights Affairs under President Abdul Rahman Wahid, and subsequently as Minister of State Secretary under President Susilo Bambang Yudhoyono, I had opportunity to learn firsthand how legal policies are formulated and implemented. During the period, I was also entrusted as a member of the drafting team for the amended 1945 Constitution. Now, as the coordinating minister for law, human rights, immigration, and corrections, I once again bear the significant responsibility of overseeing the entire national legal systems. In addition, I have served as a professor of constitutional law at the University of Indonesia since 1998, making the academic work an integral part of my professional calling. With this background, allow me to share a few reflective thoughts drawn from intellectual, practical, and technocratic experience. The law must grow from the concrete experience of the people, not merely from the theoretical obstructions. However, our journey of the legal reform remains unfinished. We continue to witness a stark gap between the formal law written on the paper and sense of justice felt by the people. Too often, the poor find themselves trapped by the rigid regulations, while wealthy escape punishment. As Professor Chipto Raharjo once stated, law exists for human beings, not human beings for the law. This means that the law must serve the needs and the human values of the society. It is within the context that we must observe the classical phenomenon of injustice. Justice is not always achieved merely through procedural or formal equality, but justice must also ensure accessibility and substantive justice. The Indonesian law, media, even road to justice is not purely formal equality before the law, but substantive equality. This means the affirmative measures are needed to provide special protection for those who have been structurally marginalized from the very beginning.
Ingin tahu bagaimana orang mendapatkan foto-foto indah?
Nevertheless, various positive steps have been taken to expand access to justice for the people. One of this initiative is the establishment of the legal aid post or post-bantuan hukum or post-bakum, which serve as the quick response mechanism to the public's need for inclusive and easily accessible legal aid services, particularly in the rural areas. These programs aim to expand access to justice in an equitable manner. This year, the National Law Development Agency, or Badan Pembinaan Hukum Nasional, has set a target to establish 7,000 post-bakum out of the approximately 80,000 villages sub-district across Indonesian territory. As of October 1, 2025, there are already 36,547 post-bakum established through the country. Ladies and gentlemen, in the digital era, legal challenges have become increasingly complex. Technologies such as artificial intelligence, blockchain, and smart contract have begun to penetrate the legal domination, demanding the judicial system to adopt. The Supreme Court has initiated in a transformation to the implementation of the court's e-court system and online publication. However, a shift in mindset of judicial approach is also required to anticipate the unique characteristic of cases in the digital age. At the same time, a new phenomenon has emerged on social media, reflecting a crisis of trust in the legal system. No viral, no justice. Cases that go viral often receive greater attention from the law enforcement, while those do not tend to be overlooked. Recent studies reveal that the public pressures driven by the viral exposure can indeed accelerate institutional responses, but also risk compromising the due process of law and creating disparities between viral and non-viral cases. As concluded in the study, justice should not be determined by the media exposures, but by the integrity of the legal system that upholds certainty, substantive fairness, and the protection of the fair citizen right. Therefore, public participation to social media must be accompanied by the balanced regulation. Authorities should remain responsibility without becoming reactive to the viral pressures, while the national judicial system must uphold the principles of equal treatment that every case, whether viral or not, must be handled fairly, transparently, and professionally. Still, within the framework of the substantive justice, it is important to highlight the impact of socio-economic inequality on law enforcement. Indonesia continues to experience a high degree of class disparity, which is reflected in how law operates. Frequently, unequal law enforcement for the exacerbate economic injustice. Ordinary citizens who dare to challenge cooperate or governmental policies are often perceived as the disruptors of the public order and can even be criminalized. For instance, villagers opposing national strategic projects are frequently charged under criminal provision for defending the customary land rights. Conservatively, those with significant economic or political power often escape legal accountability, even then their action harm to the public. The 2024 oil and gas mafia cases, the food crisis, and various project allocation scandals all reinforce the perceptions that the law has yet to deliver substantive justice. Therefore, the reform agenda must position law as an instrument to reduce inequality through legal policies that strengthen distribution and protects the economic rights of marginalized communities. Pro bono legal aid and access to justice for the underprivileged must be expanded. So, the principle of justice is not merely a moral ideal, but a tangible reality. Speaking of the legal development, several significant issues have emerged this year. First, the new Indonesian Criminal Code is set to come into full effect in early 2026. Article 613 of the new Penal Code, KUHP Baru, mandate the government to enact criminal adjustment law to ensure that all existing criminal provisions are harmonized with the new national criminal system. The government is currently expediting discussions of the bill to ensure that the implementation of the new criminal code proceed effectively without overlap with previous regulations. In light of this, several other legislative initiatives are also being prepared, including the law in the transfers of prisoners between the countries, the law of restorative justice, and the law on assets forfeitures. Collectively, these initiatives aim to establish a modern, equitable, and legally certain criminal justice system for Indonesia. Second, the law on the Indonesian National Armed Forces is currently undergoing a judicial review at the Constitutional Court, filled by the civil society coalitions. Several provisions in this law have drawn public attention as they are considered to potentially allow active military personnel to hold civilian positions, thereby blurring the line between the military and special and civilian spheres. Such a situation could undermine the principles of the civilian supremacy and heighten the risk for the politicization within the security apparatus. Therefore, it is crucial to ensure that democracy and the rule of law are not compromised by the short-term political interests. Third, the ethical crisis within the judiciary continues to recur. Recently, the public has been shocked by the several problematic judicial cases. For instance, the designation of three judges from Surabaya District Court as suspect in the bribery case involving Ronald Tanur underscores the urgent need to restore the integrity of the judicial institutions. Such incidents highlights the continued necessity for strict oversight and professional ethics development for members of the judiciary. Fourth, human rights issues remain a major challenge for our nation. Cases of human rights violations continue to occur across various regions, particularly those involving abuse of authorities, social conflict, and restriction of freedom of expression. The civil of armed conflict in Papua and the poor enforcement of human rights demonstrate that our policies must prioritize civilian protection and humanitarian dialogues. Similarly, issues such as torture, in law enforcement, criminalization of expression, and the protection of humans and children's rights frequently arise. Building public trust required consistent human rights enforcement, transparent and accountable investigation of violations, and the protection of the vulnerable groups in the justice system, such as female detainees, children, and persons with disabilities. In the context of justice reform, we must also pay special attention for the indigenous communities, women, children, victims of violence, prisoners, persons with disabilities, and other vulnerable groups. For example, harmonizing the national law with customary law is crucial for the social justice because, as Professor Supomo stated, customary law is the soul of the Indonesian law. The grassroots realities of the indigenous communities must be respected in policymaking, in law enforcement. Development must not come at the expenses of their land rights and cultural heritage. Similarly, women and children require extra protection from violence and discrimination. Institutions for child protection, special unit for handling cases involving women, and the fulfillment of the children's rights to education and health care must be strengthened so that future generations can experience justice. Among persons with disabilities, the implementation of disability law has not yet been fully effective as social stigma and physical cognitive barriers to accessing the court still need to be addressed. Special attention must also be given to the prisoners and correctional inmates. Our correctional systems still often emphasize punishment, retribution, while neglecting rehabilitation. Many correctional facilities operate over capacity, and inmates frequently do not receive skills training necessary for the reintegration. Yet, the ultimate goal of the criminal law is to return citizens to society as productive members. Therefore, we must shift a reintegrative approach, providing programs for social development, education, and mental health within correctional institutions. Incarceration should not be merely confinement, but a process of restoration. This requires collaboration between the Ministry of Law and Human Rights and the Ministry of Social Affairs, as well as support from the universities to develop training models that have real impact. Indonesia's public sphere also called for the refinement of religious and customary law within a constitutional framework. Discussion on Islamic law frequently arise, such as reform to the marriage law, provision criminalizing adultery, or implementation of religious criminal law. It is necessary to balance the religious rights of Muslim communities with Indonesian diverse society. The government should approach this through collective ijtihad, aligning religious norm with the human rights principles and the Constitution. Various reforms have already been undertaken, such as the establishment of the Kurdi religious affairs chambers to integrate the management of the Islamic law within the judicial system. Furthermore, the Hajj law, the Zakat law, the Waqf law, and provisions for chemical castration of the pedophile demonstrative the adoption of the Islamic law in a way that is responsive to the contemporary context. The guiding principles is that the Islamic law in Indonesia must be inclusive and adaptive, upholding the dignity and safety of the community without contradicting to the state basis of the Pancasila. The same applies to customary law. The recognition of the civil law in the new criminal code represent a significant step forward. The KUHP stipulates that customary law applies locally and must be regulated through regional regulations. Except in Aceh, of course, that Islamic criminal law implemented in Aceh as far as it is adopted by the peraturan daerah or the kanun of the Aceh, that the Islamic criminal law implement for the Muslim community in Aceh. However, this integration is not without challenges. The new KUHP also emphasized that customary offenses must not conflict with Pancasila, the 45 Constitution, human right, or general legal principles. In other words, customary law is respected as long it doesn't violate universal values. The process of establishing binding customary regulation should actively involve customary institution and ensure legal clarity for the citizens. Reform of customary religious law must work in synergy, but sources are part of the nation's rich legal heritage that must not be neglected, provided they are bridged with the universal principles of justice. Overall, we must continue to balance local values with universal human rights principles in the drafting of national legislation. Pancasila embodies the philosophy that humanity and social justice are the soul of the state. Therefore, both the legislative process and judicial practice must reflect values of the solidarity, respect for the local wisdoms, and the guarantee of the human rights. As I have emphasized before, legal reform cannot rely solely on legislation. It also emerged from progressive judicial interpretation, civil society advocacy, and academic innovation. No single party holds a monopoly on the legal truths. The government's role is to orchestrate the various sources of the law, Western, Islamic, customary, and jurisprudence so that they all work synergy without neglecting without neglecting one another. In building a living legal system, we should learn from successful international practices such as Germany, constitutional review, French codification, South Africa's recognition of living law grounded in human rights. The key point is that integrating human rights with the local values must form the foundation of the legal reform so that our law maintains strongly legitimacy in the eyes of the people. In the context of the legal reform, law faculties at the universities play a significant role, and it is very strategic. Universities must serve as laboratories of the legal thought. Academics need to develop progressive ideas on justice, such as concept of restorative justice, progressive law, or new exclusive jurisprudence. Law school should also strengthen the legal clinics to assist vulnerable communities, as well as to conduct collaborative research with the NGOs and government on current issues such as the revision of the criminal code, maritime government as Baitul Maqdis, and decriminalization. Furthermore, collaboration with the international academic networks broaden perspective, which should then be absorbed and adopted to the international legal context. The academic community must be actively involved in lawmaking through policy studies and monitoring the implementation of legislation in the field. With the involvement of universities, egalitarian legal theory can be consolidated as a reference for the government's policy. As a professor, I firmly believe that the integrity of law students and lecturers is a guarantee for the sustainability of just and fair law enforcement in the country. Distinguished guests, ladies and gentlemen, let us realize the aspiration for the legal systems people-centered. We are determined to build a system of law that is fair, human, and society just. This means enforcing regulations with concern, ensure that the law protects the vulnerable, and holding the principles of universal humanity. As Professor Supomo reminded us that customary law is the essence of our legal identity. Let us use the cultural roots and aspiration of the people as driving force of reform. It is our collective responsibility, executive, legislative, judiciary, and academia to articulate Panchasila in every law and judicial decision. Indonesia needs legal policies. They are not static but dynamic and responsive to the demands of the times. I'm confident that if we work together, strengthen the integrity of judicial institutions, and open spaces for the public participation, this crisis of trust can be overcome. Legal reform is not a competition to produce more laws, but rather the development of an international ecology that makes norms work. The state formulates the laws, the courts interpret the law, the legal profession sets standards, academics test them, and society brings them to life. We need strong legislation, but we also need judges who are courage and argumentative. We need contractual and compound standards that lower transaction costs. We need academic writing that can access impact, not merely embrace problems. And we need space for customary law that is grounded in empirical needs, not just romanticized ideals. In conclusion, we should once again inspire ourselves with our national motto, unity in diversity. Let us unite in legal reform, prioritizing dialogue and wisdom so that the law truly becomes the champion of the justice. May Allah subhanahu wa ta'ala, God Almighty, always guide us in holding justice and standing on the side of the people. Thank you, ladies and gentlemen. Assalamu alaikum wa rahmatullahi wa barakatuh.